In this video, we're going to cover 7 common mistakes that a divorcing couple might make when using a QDRO to divide retirement assets. So the first thing we should probably do before we cover these mistakes is better understand what a QDRO is. So QDRO stands for a Qualified Domestic Relations Order. And a QDRO is used to divide qualified retirement plan assets in a divorce. So this is specifically referring to qualified retirement plans such as, or otherwise known as ERISA plans. So your workplace retirement plan such as a 401k or 403b. So let's just imagine Couple A, Mary and John, are getting a divorce. John has a 401k at work. Mary has IRA assets. If they were each to divide Mary's IRA, then they could simply do that without having to have a QDRO. They would work that with the IRA custodian. They would probably set up a separate IRA for John, and then they could arrange to have the custodian transfer certain assets from Mary's IRA into John's. However, when it comes to John's 401k, in order to do the same thing, you need to have a QDRO on file. So a QDRO is a legal document. It's usually drafted by the divorcing spouse's attorneys, specifically the non-employee spouse's attorney. So the first mistake that a couple can make when it comes to a QDRO is just assuming that you're going to get a QDRO from the divorce process that tells the plan administrator what to do. So there are a couple of hiccups with this. Before we get to those hiccups, there are 4 basic fundamental facts that you should know about a QDRO. So first, no qualified plan can divide retirement assets without a QDRO, and this dates back to the Employee Retirement Income Security Act, also known as ERISA of 1974. So the second thing is that the judge in a divorce case does not draft the QDRO. Again, that's up to the lawyers. It's not automatically included, so the person who stands to lose the most if a QDRO is not properly done, which is usually the non-employee spouse, should be the one that's driving this process. But the most importantly is that you cannot draft a QDRO that tells the plan administrator to do anything that is not already allowed in the plan. So every retirement plan has what's known as a summary plan document that lays out all of the possible things that the plan allows participants to do. So if you draft a QDRO that tells the plan to do something that the plan expressly forbids, then the plan administrator does not have to abide by that QDRO. So how do you avoid this particular mistake? Well, the non-employee spouse should probably make the QDRO a high priority before the divorce is final, because a QDRO might take longer than the divorce paperwork to get finalized. However, once the divorce is finalized, everyone's going to move on with their lives, and the attorneys are probably going to move on to the next cases. So it is very important for the spouse who stands to lose the most if the QDRO goes awry to hold firm and make sure that they get a quality QDRO. And that means holding the lawyer accountable. So most attorneys will probably agree that it's the non-employee spouse's responsibility to ensure that the judge signs a QDRO and that the 401k administrator accepts the QDRO. So it is in that spouse's interest to avoid the distribution mistakes. You In some cases, you can have the plan administrator review the draft QDRO to make sure that it complies with the plan document before you actually finalize it. And this would be a good opportunity to familiarize yourself with all employee benefits. So again, this is for the non-employee spouse who might not know what their spouse normally was electing during open enrollment season. But let's imagine that you look at employee benefits and all of a sudden you see that there's a cafeteria plan. Oh, what's in the cafeteria plan? Oh, it could be a flexible spending account. You could possibly stumble upon your spouse's health savings account that they've been chipping away at and just saving money into. All of these benefits should be on the table when you're negotiating. So while you're drafting the QDRO, you can absolutely take a deeper look into the rest of the employee benefits to make sure that you're not overlooking anything. So mistake number 2 is taking a taxable distribution when you don't have to. And there are a couple of mistakes that usually lead to this result. But the bottom line is, unless both spouses are going to be cash strapped, in a lot of divorce situations, there should be a way to make sure that each spouse is able to at least live for the relatively near foreseeable future without having to dip into retirement assets. Might not always be possible, but if you have a decent amount of savings accounts and you have a decent amount of investment accounts, you may be able to find ways to draw down some of those accounts if you have home equity without having to take a distribution from a retirement account and possibly taking a 10% penalty for an early withdrawal. But a lot of times the distribution is taxed as an afterthought, mainly because there's a mistake when it comes to transferring the account to the non-employee spouse's account. So like I said earlier, when it comes to an IRA distribution, IRA custodians can set up a separate IRA, or if you already have one, you can transfer assets. It's pretty easy. Sometimes you can do that within an employee plan. You can carve off a separate 401k account at the administrator sets up for the ex-spouse pursuant to a QDRO. So a properly drafted QDRO could help establish a separate 401k account. But a lot of spouses might decide that they would rather just transfer it into their own IRA. So generally speaking, the plan administrator will cut a check to either the account custodian or to the ex-spouse. So if they cut the check to the plan custodian, that's known as a direct rollover or a trustee-to-trustee transfer, as long as the participant does not actually touch a physical check, or if they do, as long as they don't have the ability to cash it because it's in the name of their plan, then they should not be paying taxes on that at any point. However, sometimes people will just ask that the check be made out to them directly. Now, there is a way to transfer this tax-free under the Internal Revenue Code. It's known as a 60-day rollover. In other words, from the time that the check is made out and leaves the account, you have 60 days to be able to transfer it into a pre-tax account. So that presumes that you have the IRA already set up, and you're actually going to, as soon as you receive the check, be in a position where you can immediately deposit it into your IRA. However, generally speaking, the IRS requires that retirement plan distributions, not including direct rollovers, are subject to a 20% withholding. So let's imagine that you're splitting John and Amy's 401k, John's 401k, and Amy's going to get $500,000. Now, if that goes as a direct transfer to her Vanguard IRA, that's pretty straightforward. She generally doesn't have to worry about paying taxes. If for some reason they make the check out to Amy, it's going to be a $400,000 check with $100,000 that went to the IRS. Now Amy's in a position where she can deposit the $400,000, but she's going to have to make up that $100,000, which she won't get back until she files her tax return. Even if she, is able to find $100,000, she makes the account whole $500,000. Depending on the timing of the tax year, she's going to have overpaid her taxes for that year by $100,000 that she won't have access to until she files the tax return the following tax season. So, and if Amy's facing a cash crunch, she probably is not going to be able to do that. So the best way to avoid violating that 60-day rollover rule is to arrange for a direct transfer. So from the 401k administrator to your IRA custodian. Some other times, people might not have a QDRO on file, but you decide to pull out the money anyway. There is an exception in the Internal Revenue Code for the early withdrawal penalty. So the 10% penalty for people that are under the age of 59 and a half. Some of those include death. If someone dies, then their spouse can take the money out. Disability. There are a couple of other exceptions, and one of them is an exception where if the money is paid to an alternate payee under a QDRO. So if you draft a QDRO that says Mary is going to receive, $50,000 of this, $10,000 is going to be withdrawn, go into Mary's bank account, and then the other $40,000 will go into a 401k account that we opened for her. Then the $10,000 is taxable, but it's not subject to that $10,000 early withdrawal penalty. And then finally, the other mistake that you can make is that you just don't have the IRA set up. So when you get the check, you're already in the hole because you don't have an account to put it into, and you have to go through the process of opening the account and making sure that you're able to make deposits and things of that nature. So have your account set up in advance. So how to avoid this mistake overall? Spell out exactly what you want to happen in the QDRO. How much money do you want in another account? Which account will that be transferred to? This can be an account that's already set up for you as the alternate payee, another account that you've established. How much money do you want directly dispersed to you? And then also arrange for a direct transfer or a direct rollover. So mistake number 3 is paying an unnecessary tax penalty. As I previously mentioned, one of the exceptions of the early withdrawal penalty is to pay out pursuant to a QDRO. So as you're looking through all of your documents, if you are planning for the foreseeable future, what life might look like for you 1 year from now, 3 years from now, 5 years from now, if there's a possibility that you think you're going to need some of that money sooner rather than later, you can always figure out a way to invest extra money, but you might not have that same luxury of being able to pull it out at a later time. So if you pull out extra money while you are still married, then you may be in a better position tax-wise. So let's imagine that you are sharing custody of children, and you are claiming head of household, and then the next year the other spouse claims head of household because under your custody arrangement that that person's going to have your child a little bit longer the next year. So you may decide that you want to time your withdrawal so that you take advantage of your tax filing position. The head of household tax filing status has bigger windows for you to remain within a lower tax bracket, and you may be able to time your withdrawal so that you're paying less money in taxes. If it's pursuant to the QDRO, then you're avoiding a tax penalty. Then if you were to go back, say 2 years later, because you're in a crunch and you need that money, now you've got to pay more, possibly. If you're in a different tax situation, you might be in a higher tax bracket, even though you don't feel like you're making more money. And then on top of that, you're paying the tax penalty. So take a very hard look at what your income needs, your cash needs are going to be 1, 3, 5 years, from now. If you're, for example, if you're receiving the family house, what deferred maintenance are you going to have to pay for in the next couple of years? Do you need to replace an air conditioning unit? Do you need to replace your roof? Those major expenses should all be part of your factoring if you need to take money out of that retirement account sooner rather than later, and put that up front in the QDRO. That's how you avoid that mistake. And then whatever it says, do not take more, resolve yourself to not take more money than what's specified in the QDRO. Okay? So, another mistake that people make is overlooking employer contributions. So, generally speaking, when you look at a 401k plan, if you're looking at your spouse's plan, you might be looking at what their contributions are, and you might just kind of gloss over the employer contributions, possibly because they might not be vested yet. So, you might not see the whole story, but it might be a significant amount of the account balance. So the way employer contributions work, so if your spouse contributes 5% and they match up to 5%, 100%, you might have an account balance with, $50,000 worth of contributions on the employee side. There might be another $50,000 of employer contributions that may or may not have vested yet. So vesting basically means that employer contributions that have vested are the employee's contributions to take whenever they leave, versus unvested or non-vested contributions. They disappear if the employee walked out the door tomorrow. So in that scenario where you have $50,000 of employee contributions and $50,000 of employer contributions, if you're overlooking vested employee, let's just imagine that of the $50,000, $20,000 have already vested. So now there's $70,000 of vested contributions to include the employee contributions that are always vested. So $70,000 over here, you decide to split that. If you're not looking at the other $30,000, then all your ex-spouse has to do is just keep working and not leave their job, and they've got that extra $30,000. So you need to make sure that when you're dividing your retirement plan assets, that you include vested and have something to say about non-vested employer contributions. So if your ex-spouse is entitled to the employer contributions that have vested, then you need to make sure that you're part of that. And then you could probably negotiate some sort of fairness, in recognition of the non-vested contributions that they will probably end up with down the road. So make sure you just ask those questions and understand that. So in order to avoid that mistake, you should ensure that the financial affidavit and all the supporting documents include all employer contributions. So you should be on the lookout for that. And that the equitable distribution worksheet that hopefully you and your lawyers are putting together includes all employee and vested employer contributions. And if there's a significant amount of non-vested contributions at stake, that's what you should talk to your lawyer about. So, mistake number 5, not understanding the difference between different plans. So there are a couple of different types of differences. We'll talk about Roth accounts versus non-Roth accounts. So, probably the most obviously sneaky type of devious negotiation would be just telling your spouse, hey, I'll keep the Roth IRA and you can take the traditional IRA. And it's okay because the traditional has a little bit more money in it. They're all the same. So they're not the same because the person that ends up with the Roth account will never have to pay taxes on qualified withdrawals, while the other person not only is subject to taxes, but could be subject to early withdrawal penalties if they need that money sooner than they expected. So qualified distributions from a pre-tax plan will always be taxed, right? Even if you avoid a penalty, you're still paying tax on it versus the Roth IRA. So make sure that you have a good understanding of what's a pre-tax account or a traditional account and what's a Roth account, and make sure that you understand, how that should work. And the best way to do that is to have someone explain it to you. If it sounds fishy, it's probably not legitimate. So have someone explain it to you, ask questions make them explain the difference. And then ask questions like, is there a tax difference between those two plans? What's the difference between a Roth plan? Even if you don't understand or you don't feel comfortable with the concept of taxes and finance, you can kind of use that into a strength by making other people explain things to you, slowing down the conversation, and making sure that you don't leave the conversation until you are good and confident that they've explained everything to you adequately and they're not taking advantage of you. So another difference between plans would be a defined benefit plan versus a defined contribution plan. Now, defined benefit plans are also known as pensions. So think of your traditional, like grandfather's pension, where after 40 years on the job, you're retired with a pension and a gold watch. That's a defined benefit plan. Military personnel still deal with pensions. And there's a lot of complexity that can happen specifically when it comes to, the pension payments and your right to an ex-spouse's pension payments versus the defined contribution plan. So to avoid making a mistake with that, make sure you understand everything that's at stake. The good thing about the military spouse community is that there are a lot of supportive military spouses that have probably been in your shoes. And there are lots of online Facebook groups and other communities where you can ask questions and feel comfortable that you're going to get a good answer. If you're talking about pensions from a company that still offers them, there's probably maybe a smaller group of people that are as experts, and you might need to seek them out, and it's very difficult if you're not already in the workplace and knowing who is, the subject matter expert or who's the unofficial financial expert for those plans. But as financial advisors become more and more specialized, if you work for a large company, you might find there's a financial advisor out there that works specifically with employees of specific companies. And that would be a good person to be able to help review benefits and pensions and plans of that nature, because they will also know those systems inside and out. Mistake number 6, not accounting for company stock. So many employer-sponsored retirement plans offer either stock purchase or stock option plans. And if you're, or they might have something that's known as restricted stock units or RSUs. And so those are becoming increasingly popular with companies who don't want to just give away stock, but they do want to use it as a financial incentive to keep employees around. So the way these benefits might work is that you'll have, stock or an RSU schedule, vesting schedule. So you might receive options or RSUs in a given year, and you might have to stay for an extra 3 years for them to vest. And then once they vest, they automatically become stock. There are ways for an employee to completely hide this from a spouse so that they never even know that that's in existence. So when you, as the non-employee spouse, are looking into this, make sure that you're asking about company stock. What is the RSU program? What is the company's plan for this? Are you participating in this? Are you in a position where you do get RSUs? What does your RSU grant schedule look like, your vesting schedule? These are all questions that you can ask either the attorney to kind of pursue. You can ask your financial planner or your financial advisor to kind of dig a little bit deeper into this. Or you can, increasingly, there are financial advisors that specialize in divorce, known as certified divorce financial analysts, that are specifically versed in helping people understand all of this. And then the last mistake that people make, mistake number 7, exposing assets to creditors unnecessarily. So if you're in a position where you might have trouble making ends meet and you might have creditors coming back to you, there's a very important distinction between ERISA plans, like the qualified retirement plans, and an IRA. And specifically, that difference is that ERISA protects most employer plans from creditors, either in bankruptcy or non-bankruptcy situations. Under federal law, those are protected. So once those move from an ERISA plan to an IRA, the rules kind of change. So in a bankruptcy case, as long as the money originally came from an ERISA plan, your IRA assets are probably still protected. But in a non-bankruptcy case, then state rules might apply. So this isn't legal advice. It's kind of a general education where you might encounter more risk in a particular situation if you think creditors might be involved. So if you think creditors might be involved, you might err on the safe side and try to keep your money in an ERISA plan to the extent that you can, instead of just making an arbitrary decision to put it into an IRA and possibly risk those assets being subject to forfeiture or seizure. Now, again, you should probably discuss that with your attorney, very specific situation if that comes up. But it is a common mistake. And again, getting your legal advice from your attorney will help you make the best possible decision. So that's all we have for this video, and we've written an article that goes a little bit more in depth. You can find it on our website. Simply go to teachmepersonalfinance.com and then type in QDRO, QDRO, into the search bar, and you should see this article appear. If you like our articles, please subscribe to our newsletter. And if you like our YouTube videos, please subscribe to our YouTube channel. If you have any questions or comments, please post them in the comment section. Thank you very much and have a great day.